Could I have the two gentlemen that are in custody brought in, please? Thanks a lot. Mr. Tipton, can you hear us okay?
Yes, I can.
Thank you.
No, I don't need
Is Mr. Walsh there on the video? I just don't see him. I don't need to see him, but is he there?
I don't see him.
Yeah, no, neither do I.
Yes,
the
sir.
sheriff's office is there.
Yeah,
I just don't. Here we go. Oh, maybe not.
we can go get him. 1 second.
Great, thanks a lot. Let's start with identification. Let's start with the Commonwealth.
Good afternoon, Your Honor. Lisa Beatty for the Commonwealth. I'm at the table right now. There are various other assistant district attorneys who represent the trial teams on the various cases who are also present in the courtroom.
Okay, thank you.
Good afternoon, Your Honor. We're speaking on behalf of Mr. King as well as Mr. Johnson. I am sitting in for Attorney Cataldo with respect to the co-defendant of Mr. Johnson's case.
Okay,
Good afternoon, Your Honor. Nicole Scapici on behalf of Mr. King and Mr. Johnson.
thank you. I have Mr. King in the back, okay?
Attorney Joseph Krosky Jr. on behalf of Giovanni Della Santos.
Okay,
Sitting next to
and he's here.
Sir.
Okay, very good. And Mr. Johnson is here.
He is.
On the Zoom is Mr. Tipton. Mr. Tipton, could you identify yourself for the record?
Yes, Larry Tipton for Mr. Walsh. Attorney Porges will not attend today.
And Mr. Walsh is here. Mr. Walsh, can you hear us? You can just wave or whatever.
I can hear you. Thank you.
Thank you.
All right, Mr. Tipton, we still have to fix your microphone. Still tough to hear you, sir. All right, where do things stand, Attorney Beatty?
Your Honor, I've had the opportunity to have further conversations with the U.S. Attorney's Office, and I can report the following to the court. Ordinarily, the U.S. Attorney's Office would have 2 weeks to reply to the motion that the Commonwealth filed in federal court. We've had some productive conversations, and we're hopeful that we've reached an agreement that will narrow the issues for some period of time. They will be filing a response to our motion in court seeking modification of the federal protective order, which will do a number of different things. The first thing they will be seeking a modification that will permit the release of the previous court orders so that this court can review those orders. The second thing that the motion for modification will seek is permission for the Norfolk District Attorney's Office to review the remaining confidential materials that were provided to the Reed and the Reed prosecution and defense teams. So I want to be clear at this point for the purposes of the record that at this point in time, all of the Proctor chats or communications have been produced to the Norfolk District Attorney's Office outside of the protective order, and the Norfolk District Attorney's Office has provided those to all of the defendants who are part of this motion and will continue to provide those to other defendants. However, that left the remainder of the confidential materials, which we had not been allowed to review. So the motion will seek permission for us to be allowed to review those additional materials. I would characterize those.
That's the motion that you filed before.
We filed a motion for that, seeking that among other things. The U.S. Attorney's Office will file their own motion.
And they'll file a motion in accord with yours?
No, because there are what I would characterize as two groups of remaining materials. There are grand jury materials and there are non-grand jury materials. Their motion will allow us to review both sets of materials. We will be permitted to produce Rule 14 materials from the set of records that I would characterize as non-grand jury materials. We will not need to seek further court order or permission from the U.S. Attorney's Office if we review the non-grand jury materials and find Rule 14 material that is relevant to the other matters. We're calling them the other matters, these cases here that we're discussing. We do not have an agreement with regard to the grand jury matters. So if we review the grand jury matters and we find what we determine to be Rule 14 material, at that point in time, we would have to seek either a TUI or go back to federal court and file an additional motion before Judge Casper. The third thing, this is my understanding that the third thing that the U.S. Attorney's Office motion or response, however you want to look at it, will seek is a status on this matter before Judge Casper in 45 days. So if Judge Casper agrees with that, we will not have a return or destroy deadline that is pushing the matters at this point in time.
And does the U.S. Attorney's Office also agree to the tolling during the period between now and whenever Judge Casper decides?
Yes, they had already
agreed to that.
They had already agreed to that.
Let me just see if I can recap.
Thank you.
As best as I understand it. There are two types of materials that have not yet been produced to the defendants in this case.
That have not been reviewed by the Norfolk Attorney's Office and have not been produced for these cases.
All right, so let me just go slow here.
All right.
Certain documents have already been turned over to these defendants under protective order,
Yes.
which came from the U.S. Attorney's Office.
Yes.
Okay, but leaving those aside, of the materials that are part of the confidential material from the federal court, there are two categories. One is grand jury materials and the other is non-grand jury materials.
Yes.
You haven't yet defined what you mean by grand jury materials. Presumably, if the grand jury took testimony, that would include transcripts of testimony. I don't know if the grand jury issued subpoenas. I don't know, and I don't know if you're considering subpoenaed material to the grand jury to be grand jury materials. But let's leave that distinction aside. Whatever constitutes grand jury materials, there's some other stuff that is non-grand jury materials that was collected by the U.S. Attorney's Office in connection with this investigation related to the Reed case. And what you have is an agreement from the U.S. Attorney's Office that as to the non-grand jury materials collected by the U.S. Attorney's Office and produced as confidential material in connection with the Reed case, the non-grand jury materials, even the U.S. Attorney's Office would agree to allow you to review and to determine whether anything in that material should be produced in King or Johnson or De Los Santos or any other of the cases that involve Trooper Proctor's investigation. As to the grand jury materials, they still are opposing your ability to produce any of that material and opposing your ability to review any of that material. Is that correct?
No.
No.
We are allowed to review those materials in order to determine
and
whether,
then,
in our opinion, there is Rule 14 material.
Okay. So at this point, they're taking the position that the non-grand jury material may be reviewed by you and turned over without further order, although I guess it's subject to their production of the documents to you other than through the, under the protective order.
I think that I want to, we don't have this finalized yet, but my impression was that we would be able to use the documents that we already hold.
Okay. And are they taking the position, the U.S. Attorney's Office taking the position that notwithstanding the protective order issued by Judge Casper, they can make that determination unilaterally?
No.
So they're seeking a modification of the protective order to allow them to give you the authorization to review it separately?
Yes, so this is all subject to Judge Casper's approval.
All right. And then with respect to the grand jury material, however that category of universe is defined, the U.S. Attorney's Office is taking the position, at least as in front of Judge Casper, that you can review it and all the other prosecutors involved in this case, the other cases, the related cases, can review it to make a determination as to whether it contains anything that needs to be produced as exculpatory evidence or impeachment evidence under Rule 14. And
I know that it will be all the prosecutors in the office. I think there will be at least 2 prosecutors in the office, 2 prosecutors probably who have already signed the acknowledgement, who will be able to do the review.
Okay. The U.S. Attorney's Office is asking for a status conference in 45 days. Presumably, Judge Casper might decide it much sooner than that.
I think what they are hoping is that they will file the motion, Judge Casper will act upon the pleadings, and then the 45 days would be scheduled from whenever it is that she issues her order, assuming that she adopts this proposal.
Well, what's the 45 days for?
For a status to see where we are. I don't know how long this process is going to take.
Oh, you mean a status on the return of documents after this review has taken place?
Right. I don't know if we'll be able to do the review in 45 days. I'm optimistic, but, you know, anything can happen. And so I think the suggestion was this way we don't have this deadline that is just pushing everyone. And so then we can see if we've been able to complete the review, if we can continue to discuss the issues that remain, or if there needs to be further litigation or what needs to happen.
Okay, so we are making progress, incremental progress. I have not received any new filings from you or from anybody else between the last hearing and this hearing. So all of this is being reported to me for the first time orally here in court. Maybe it's true also for defense counsel hearing it for the first time here in court. Does defense counsel have any thoughts, concerns, issues?
There you are.
I'm sure you have thoughts and concerns and issues, but you know, my gut feeling here is we're going to need another hearing on this, and I'm not sure that less than a week, you know, or a week's time, anything longer than a week might not be appropriate, because we don't know what Judge Casper is going to do. We don't know if she's going to adopt the tolling. We don't know whether.
That's exactly
what
Judge Casper says.
Right. Right. It seems to me unlikely that she would say no, but I don't know, and I can't assume the conclusion here. So,
is there, I guess, can I ask a question, Judge?
Sure.
Is there any agreement between the Commonwealth and the U.S. Attorney's Office not to destroy the documents until Judge Casper makes a decision? And can we have a day after that decision to get in here and talk to you?
What do you think?
Well, I've always said that we would not return or destroy before Judge Casper made a decision, and that the U.S. Attorney's Office has agreed to that. I do want to say that I'm out of state next week, so I would be asking to go to the following week. If something comes up, I can get on Zoom if necessary, but.
So the only concern I have, and I'm never going to interfere with anyone's vacation. The only concern I have is if Judge Casper makes a decision tomorrow or Monday that says this order isn't getting extended for whatever reason, we're out of Judge. That's my concern. Because this order expires, the order that we have right now, I know there's an agreement between the Commonwealth and the U.S. Attorney's Office, but it's not their order, it's the judge's order. So if the judge says no on Friday or Monday, then what happens?
What do you think?
I will notify the court, and I will get on Zoom if that happens.
Okay.
Just on behalf of Mr. De Los Santos, again, in theory, this does sound like progress. I do share the concern if a decision comes out from the federal court from Judge Casper. I'm comfortable enough with a 2-week date, with the caveat that if circumstances on the ground change and the landscape in federal court changes, that we could have this case advanced to address the court.
That's where I was coming down, okay, is put this on for a next hearing, August 27, 28, 29, something like that, convenient to the parties, dog days of August. with the additional order that upon a decision by Judge Casper, all parties, all defense counsel, and the court will be notified within 24 hours so that we can accelerate proceedings on this case, if need be, before the 27, 28, 29.
So Judge, I'm not available on the 27th because I have an all-day motion for new trial here in Suffolk. Do what I have on the 28th, make myself available if that works for the court and the parties.
The 28th or the 29th is better.
I'm here on the 28th.
Okay, so the 28th at what time?
At 2?
Yeah, let's do 2 o'clock.
Sure. And may Mr. Johnson be here, Jen?
Yes.
And I'll have Mr. King here.
Same with Mr. Delasanto.
Okay. Mr. Tipton, how do you look on the 28th of August?
I'm fine, Judge. I'll appear, if I can, I'll appear by Zoom. If I can be present, I'll be present, but I'm there.
Okay. Zoom will be an option for you.
Thank you, Ron.
Anything else we should take up?
Judge, I don't want to believe.
Looks like we're making some progress, and I feel confident now that the information isn't going to be destroyed by Monday, and if it is, we'll have an opportunity to speak to you before that happens.
Okay. Mr. Tipton?
Yes.
The only thing I want to say, and I'm not going to belabor it, we'll address it on the next one, but we have, in my case, we have a trial date coming up in October. If we're talking about 45-day status date, then we're talking about the grand jury, then we're talking about TUI. I'm just putting a bug in everybody's ear that we do have an October trial date, and everything needs to be done expeditiously in the Walshe case at a minimum. I'll leave it at that.
The Commonwealth is mindful of the Walshe trial date and has expressed to the U.S. Attorney's Office that we are anxious to bring that case to trial and do not want there to be any delay, and we will be acting accordingly.
Judge, the only other concern I have is the 2 attorneys that are going to be authorized. I would assume that they would have conversations with the attorneys that are assigned to the case so that they know.
I'm not going to micromanage the district attorney's office's obligation to produce all exculpatory evidence. They will have to bring somebody up to speed so that if they are limited in who can review the capital C, capital M confidential materials as defined in the various orders, that those people are in fact up to speed.
Thank you, Honor.
Okay.
Thank you, Your Honor. Thank you, Mr. Clerk.
Thank you.
Thank you, sir.
Sure. 27 at 2 p.m.
28th, I believe.
28, yep.
28, sorry, 28 at 2 p.m.
Thank you.
Thank you.
Thank you. Thank you, sir.
Thank you. Could I have Mr. Buckley brought in? Sure.
Tomorrow, can we we just need
Your Honor, you're all set with the Norfolk Sheriff's Office?
Yeah, you're all set. Mr. Walsh is all set. Thank you.
Thank you, sir.
Yeah. So to the 28th? Great, thank you. Sure.
Thank you, Honor. Thank you.
Hey, can you let Amanda know, Amanda Mulaney?
I'll let her know.
Yeah, great, thank you.
Motion under advisement, Judge.
Great, thank you. Yes, I'm sorry. Yeah, I thought it's all for tomorrow. Do you have under advisement? Ricardo Charles, he just wants to move that.
This is the new one.
Good to know.
Good that I kept you in the loop. Mr. Buckley is present. Could I just have the parties identify themselves for the record?
Good afternoon, Your Honor. Rachel Boyce with Probation.
Okay.
Good afternoon, Ethan Yanklowitz. I'm standby counsel for Mr. Buckley, who's representing himself.
Okay. Mr. Buckley?
Yes, hi. Good afternoon, Brian Buckley.
Yep. So because my memory is not so good, I keep notes. And so the last time we were together, my notes reflect that found Mr. Buckley competent to proceed. He opted back a month ago to represent himself. Mr. Yankowitz was going to serve as standby counsel. The only probation violation that was alleged is failure to complete an anger management course that Mr. Buckley had been held for about 20 days. And I did a colloquy with Mr. Buckley. He admitted to the violation, and I accepted his waiver of hearing and his stipulation to a violation, and I scheduled us for today for sentencing.
Yes, that's the first matter, Your Honor.
Okay.
Since then, there has been some more, more has happened. On July 20th of 2025, he was in the town of Hingham, and he was arrested there and charged with assault and battery on a police officer, 3 counts of that, resisting arrest and walk or ride on a track. That will be a...
Resisting arrest and what?
Walk, ride on a train track.
Oh, I see. Okay.
And then he, so essentially this would be an initial surrender for that.
Well, first things first. First thing is sentencing with respect to the violation as to which we had a hearing back a month ago.
Right.
Do you think I should put that sentencing off until we have a hearing on the new violation?
No, Your Honor. My recommendation wouldn't change.
Okay. And do you agree we should go forward with the sentencing on the a violation that we had, I found you in violation of on September 15?
Yes.
Okay. So why don't I hear from the parties with respect to sentencing? I'm sorry, Mr. Yankowitz?
I know I'm only standby counsel, but in my conversations with Ms. Boyce and Mr. Buckley, I think Mr. Buckley would like to, if the court would let him waive the time necessary for a final surrender hearing, and wants to stipulate to the new violation as well today.
That's correct. I'm here to stipulate to the new violation as well.
Okay. I don't have a violation package.
Yes, I just placed it on your desk, Your Honor.
Oh, okay.
Yeah.
Sorry.
Everything's in there that you would need.
This big package?
Yes.
The top says
Yes, the first,
notice of alleged probation violation.
the first packet is the
I
older
see.
case. The next packet is the new case.
All right. Have you provided the notice of the new violation dated August 1, 2025 to Mr. Buckley?
Yes.
Okay. So, Mr. Buckley, you've seen this. It's the notice of violation which asserts that you engaged in the following criminal conduct in a new charge, 2558 CR 545, which is in Hingham District Court, July 20, 2025, ABPO ×3, resisting arrest and walking or riding on a track.
That's correct.
You saw this. Okay. Okay. Let me, as I did with the last violation hearing a month ago, I'll hear you with respect to this. I need to ask you some questions with respect to this one.
Yes.
So we need to have you sworn in, okay? If you could.
Mr. Kid, you solemnly swear the evidence you give the court in the case there and hearing to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
All right. Would you state your name for the record?
Brian Buckley.
All right. Mr. Buckley, I heard last time a little bit about your educational background. Can you tell me whether you have taken any medication today?
No, sir.
Have you had anything to eat or drink, drugs or alcohol or anything else that would interfere with your ability to understand what's going on here today?
No, sir.
All right. Do you feel like your mind is clear?
Yes.
All right. In connection with the new probation violation, Mr. Yankowitz is here and will be appointed to represent you if you wish him to represent you, or you can represent yourself as you did in the previous violation and have him serve as your standby counsel. Do you understand those things?
Yes, I understand.
And what would you like to do? Would you like him to represent you in this new matter?
No, I'd like to represent myself as well and still have Mr. Yanklowitz as a standby counsel, if that's
All right.
fine with you, Judge.
Okay. Has anyone forced you or threatened you in any way to get you to waive your right to counsel and just have counsel be standby counsel?
No, sir.
Okay. Has anyone threatened you or forced you in any way to give up your right to a hearing with respect to this new violation?
No.
Okay. You understand that you're charged with new criminal conduct in connection with this new violation.
Yes, I understand.
And you understand that you have a right to have a hearing on that new violation. And during that hearing, it would be the obligation of the probation office to come forward with evidence to demonstrate to the court that you in fact committed this new violation. Do you understand that?
Yes, I understand. I'm here to stipulate to the violation.
All right. Has anyone promised you anything in exchange for your decision to give up your right to a hearing and to stipulate to the violation?
No, Judge.
All right. I will accept your waiver of your right to a hearing. I will accept your stipulation to this new violation, and I'll hear from the parties with respect to disposition and what I should do in connection with this, these two violations. The earlier violation with regard to failing to complete the anger management program and the new charge.
Thank you.
Thank you, Your Honor. Probation is recommending today that Mr. Buckley be released on a GPS bracelet with the condition that he remain out of the town of Hull, because that is where the victim from the underlying case lives. And in the first violation, he did make some unsettling remarks about wanting to get his children and things such as that.
Can you speak into the microphone? It seems like Mr. Buckley's having difficulty hearing you.
He did make some remarks about wanting to get his children. I understand that's very difficult for him. However, there is an active restraining order which his children are named in. The victim in the underlying case has also told me that some of her neighbors have seen him in the vicinity of her home since being released, which makes her very nervous as well. I reached out to Bay State Community Services to see if he could be reinstated on the Intimate Partner Program. They said yes, he can. He would have to pay his past owed balance of $110 and then schedule and attend a re-enrollment intake, which would be about $50. And then after he does that, he can continue on with where he started or where he finished. He wouldn't have to start over with that. Also, I have talked to their mental health unit, and they have room in their agency for another patient.
I'm sorry, the what unit?
In their agency. They have another.
What's the agency?
Mental health.
Okay.
At Bay State.
And he could go back to that?
He can go back to that for both the Intimate Partner and for mental health treatment. The way it works with them is it's an all walk-in basis. They have walk-in hours on Monday, Wednesday, and Friday from 9 to 12, and then Tuesdays from 4 to 6. He would have to walk in to their facility and tell them that he wants to get mental health treatment, and they would start with an assessment process with him and see exactly where he needs to be as far as treatment is concerned.
Okay. Did you hear what was just described by the probation department?
Yes, I did, Your Honor.
Okay, and so they are suggesting that I reprobate you, I assume, to the original end date.
Yes, Your Honor.
To the original end date, so not extend probation, release you on GPS, and the GPS would be designed to enforce the condition that you remain out of Hull, that you don't go to Hull. You never step foot in the Hull, okay? And if you go into Hull, you know, the GPS is going to register it, and there's going to be a warrant out for your arrest. So it pretty much happens automatically. That you will have no direct or indirect contact with the victim in this case, that you get mental health evaluation and mental health treatment as deemed necessary, and you can do that through the Bay State program, that you enter or resume and complete the batterers program. Again, you can do that through the Bay State program. Is there a restitution order?
There was restitution ordered.
Okay.
He has been in compliance.
Okay, and so you'll have the restitution obligation that will continue. Any other conditions that I missed?
The only other condition was that he stay away, have no contact with anyone listed on a current 209A order. And I had done a referral.
Well, it'll be comply with any restraining orders. Okay, that will be the condition, is comply with any restraining orders. If you violate the restraining order, you go and contact somebody, or you have somebody else contact them for you, anything like that. That'll be a violation of your probation. Do you understand that?
I understand, Judge.
Okay. All right.
And one other, I'm sorry,
Yes.
Judge. I did a referral for BHJI a couple weeks ago, which is the justice center that helps people who have been incarcerated get back on track. They have met with him. There was a letter that Lewis Howe wrote today regarding his work with...
I think someone actually just handed this up to me.
Bay State Community Care?
Yes. And I would like him to follow through with any services that they can provide for him.
I have no idea what that means.
Basically...
No. I want to write a condition. If I'm going to write a condition of probation, I want to be very clear about what it is, so that you know what you have to do, and I know if you violate the condition, okay? And Riverside Community Care provides lots of potential services that they could provide for you. But, for example, mental health is going to be provided through some other agency, right?
Correct.
Right? Intimate partner violence program is going to be provided through some other agency. So what specifically do you want Mr. Buckley to do through Riverside?
They also have programs where they help with job placement. They provide rides. Last time they brought him home when he was released from jail. It's just if there are services that they can.
So I'm not going to impose as a condition the obligation on Mr. Buckley to get resources that some organization may or may not be able to provide for him, okay? I think Riverside may well have resources that would be helpful to you. Might be to your benefit to take advantage of that, but I'm not going to impose it as a condition.
Okay, thank you,
okay? Okay, anything else, Ms.
No,
Boyce?
Your Honor.
Okay, anything else, Mr. Buckley?
Yes, I had a small statement. It'll go quick. I've been seeking further health mental treatment with an outside provider. With the initial violation for having to go to Bridgewater, I believe I am a victim of the Abington law and systemic racism, but I'm not a risk to the public or police and will have a psychiatrist by Monday. Part of my aftercare plan is my children. My 5-year-old daughter turns 6 next month. She is very precious to me. I want to move forward with DCF for supervised visits. I've had no accurate update by DCF since they closed the case over a year ago. I want to be involved in all my children's lives. I have 3. My 7-year-old son is autistic, and I'm working with a will and state attorney to plan for my children's future so we can grow strategically. I've been working on my children's family home, which has been in our family since 1905. It was sadly destroyed by their mother, who caused hundreds of thousands of dollars worth of damages. When released, I would like to focus on my mental health treatment first. I am willing to enroll in an outpatient mental health treatment setting and/or facility to build a strong mental health support team for myself. I would like to seek further mental health treatment with an IOP plan. An IOP plan is intensive outpatient therapy.
Yep.
When I was released by yourself, I encountered even more racism on the ride home, on the train ride home. Because of my skin color, I was asked to get off the train at the next stop. This was after I explained to the conductor I was just released. I politely informed the conductor that he would have to call the police if he needed me to be removed from the train. My father has the same birthday as Rosa Parks. I've worked in Brockton on the Frederick Douglass Tree Memorial. Clones of this tree are preserved at the White House. I was not rude to the conductor. I had no phone and was too tired to get the information to report him to an MBTA official. Nonetheless, it was a traumatic experience for me, and I'm seeking more mental health treatment because of the incident. I would like to reintegrate myself back into society slowly through an IOP program. My family is small, but they are very supportive. Most of my neighbors see the improvements I've been doing on the house. I've been working hard to see my children again. I've completed a nurturing fathers course, a parenting class, and a domestic relations class. I need time just to rebuild my landscaping business to support myself and my family. I'm a good person with good morals and ethics. I just want help by the right people who want to see me succeed. Yes, I do have PTSD from police brutality over the course of 22 years, but I do not want to fight. I do not want to argue. I just want to see my children after I get more mental health treatment. My mother was a school teacher who passed away in 2009. She taught foreign language, French and Spanish, for over 41 years. On the weekends, I would help her grade and correct papers. I started correcting papers when I was 12. She passed away August 12, 2009. I've made peace with her passing, but it was hard. I was 22. I believe I qualify as an ADA patient due to all the trauma I've endured over the years. I'm asking to be re-enrolled in the Batterers program. In my IOP plan, I would like to address my trauma, work on emotional regulation, and start to discuss my family therapy plan since I have been absent for so long from my children's lives. With an IOP plan in place, I would stay in touch with Lewis Howe. To make my IOP appointments on time and safely, Mass Health provides a PT1 transportation service to mental health appointments for free. I can attend any in the state because of this service. In my treatment plan, I will apply for supervised visits with my children during the end of my treatment with my treatment team's approval. A solid goal to see my children will help me greatly in my mental health stamina to see my children safely. I understand that I'll have to ask another judge out of another court for permission to see my children. I hope we are all on the same page that my mental health treatment needs to be addressed first. I'm not a risk to the public or the police. I'm asking for the town of Hull to be added to the restraining order with no GPS. If released, may I please have a one-day travel permit issued by the court so I may go home without incident.
All right, Mr. Buckley, thank you for those comments, okay? I appreciate your commitment to maintaining your mental health, and that's a priority for you. I think getting reestablished with your family, your kids, is a terrific goal, but obviously that has to go through a proper channel, and you know that.
Yeah.
I think being successful on probation is a big piece of that.
Oh, yes, I agree.
And so what I've tried to do is I've tried to give you very specific probation conditions that you need to comply with, and I think they're conditions that you can meet, and that in your statement you articulate that you want to meet. I am going to impose the GPS condition, though. You understand that? And that's a hard condition to comply with because you have to keep the GPS device. I don't know if you've ever been on GPS before. You have to keep it charged. You have to,
It's 2 hours a day to charge it.
Right.
I understand. I've been on it before.
Okay. So where are you going to be tonight?
My house in Cohasset.
In where?
Cohasset.
In Cohasset. Okay. So, and how are you going to get there?
I have to take the train.
Okay. Mr. Yankowitz, can you work it out so that there's no problem with him getting there?
I can help him.
Okay, great. So you'll be released today on GPS on these conditions. You'll have to meet with Ms. Boyce before you leave because she's going to have to fit you for the GPS device. Okay. And then you'll be good to go. We can impose the sentence.
Yes.
Yeah.
Okay. Mr. Buckley, the court having found you in violation of terms and conditions, your probation, continues your probation, the unexpired term with the following conditions. The GPS will be with the exclusion zone of Hull. no contact with the victim, mental health treatment, resume the batterers program, comply by all restraining orders, and all other conditions remain that were originally imposed. Good luck.
Thank you.
All righty.
Thank you, Your Honor.
Mr. Yankovic, thank you.
Yeah, thanks, Mr. Yankee. And just for the record, as far as you know, Ethan, there's nothing else holding him?
No.
Okay.
He has the next date in Hingham, and he goes to bail in that case.
Great, thanks.
Thank you.
Thank you. Could I have Mr. Rivera brought in? Yeah, Ms. Boyce is gonna do it. I get yelled at. I'm sorry, did I say that? Did I say that out loud, Mr. Rivera? Yeah. Judge, this is Antonio Rivera. He's being brought in, 23309. Counsel was nice enough to help us out today, so I appreciate that.
This is a warrant I issued a day or two ago? Okay. Thank you.
And Mr. Clerk, thank you for making me aware of that.
Sure, that's what I meant. Yeah.
Yes, I saw you were
It's like, okay.
making sure I was still getting the Walshe matter.
Told him he could leave if he wanted.
I'm acutely aware that we have a quick trial date coming up on Walshe.
Thanks.